Chapter 9. Trial. Contents. Key exam issues. Because a variety of trial-related issues can arise on an exam, it is important to be alert to determine which ones are actually raised. Some that are particularly likely to arise are: 1. Is there a right to jury trial? For a party to have a right to trial by jury, he must make a timely demand for jury trial. Then the question whether there is a right to have the case submitted to a jury depends largely on the constitutional scope of that right. In federal court, it is important to focus on the following issues. A. Equitable vs. legal relief. In general, there is a right to jury trial when a party seeks legal relief, generally money damages, and there is no right to a jury trial when equitable relief is sought. Often, the historical test is used to determine whether the action should be deemed equitable, i.e., by looking to how such an action would have been classified in England at the time of the adoption of the Seventh Amendment in 1791. B. Statutory rights to sue. When the right being asserted was created by statute, the question is usually whether it corresponds to rights asserted at law in the 18th century. When a new right analogous to a right asserted at law in 1791 is created, there is a right to jury trial if suit is in federal court. But Congress may assign initial adjudication to an administrative agency that does not provide a jury trial. C. Actions combining legal and equitable claims. Some suits may include both legal and equitable claims. In those cases, the sequence of decision-making is important. The common issues must be tried first to ensure a right to jury trial of those issues. D. Equitable proceedings seeking legal relief. Even if the historical origin of the form of proceeding lies in equity, as with interpleader or shareholder derivative actions, the nature of the underlying claim determines whether there is a right to jury trial. Juries are rarely used, however, in bankruptcy proceedings, which are historically equitable. E. No right to jury trial of issues of law. Issues of law, such as construction of a patent, are determined by the court. 2. Jury selection. The method used to select prospective jurors may not systematically exclude people on religious, racial, ethnic, or political grounds. For any given jury, prospective jurors are subject to voir dire, to challenges for cause when there is ground to suspect that they may not render a fair verdict, and to a limited number of peremptory challenges that need not be justified by cause. 3. May a party obtain judgment as a matter of law, formerly called directed verdict. In federal court, judgment as a matter of law permits a party to avoid having an issue or claim submitted to the jury. A. Time for motion. In federal court, the motion can be made whenever the opposing party has been fully heard on the issue raised by the motion. B. Standard for decision. Like a motion for summary judgment, see Chapter 7. The question depends in part on which party has the burden of proof on the issue raised. 1. If the opposing party has the burden of proof, the motion should be granted only if the opposing party, i.e., the party who wants the issue submitted to the jury, has not presented substantial evidence that would permit a jury reasonably to accept its position. 2. If the moving party has the burden of proof, she must present such compelling evidence that no jury could reasonably fail to find in her favor. C. Reserving decision. The judge may reserve decision on the motion until after the jury returns its verdict. Even if the court denies the motion, the moving party may renew the motion after an unfavorable jury verdict. 4. Post-verdict motions. Ordinarily, the verdict winner will not want to make post-verdict motions, but the verdict loser often will. If such motions are on your exam, there are a number of issues to consider. A. Renewed judgment as a matter of law motion. Providing that the verdict loser made a motion for judgment as a matter of law after the victorious party had been fully heard on the issue raised, it may renew the motion. The issue of the sufficiency of the evidence will usually be the same after the verdict as before the verdict. B. Motion for new trial, either together with or instead of making a post-verdict motion for judgment as a matter of law. The verdict loser may move for a new trial. A number of grounds exist for such motions. 1. Error in evidence rulings. If the court erroneously admitted or excluded evidence during the trial, that may be a ground for granting a new trial. To preserve that ground, the moving party must have objected to the admitted evidence or made an offer of proof with regard to the excluded evidence during the trial. 2. Error in instructions. If the court made an error in instructing the jury, that is a ground for granting a new trial. To preserve that ground, the moving party must have proposed a correct instruction or objected to the instruction the court proposed to give. 3. Misconduct of counsel. If prevailing counsel engaged in serious misconduct during the trial, that misconduct may be a ground for granting a new trial if it appears to have seriously prejudiced the jury. 4. Error in the verdict. If the court has used special verdicts or a general verdict accompanied by special interrogatories, the jury's responses may have been inconsistent. The court may direct the jury to return to deliberations to cure such an inconsistency if the inconsistency is called to the court's attention before the jury is discharged. Otherwise, the court may grant a new trial, but it will usually search for an interpretation of the verdict that permits entry of judgment. 5. Newly discovered evidence. If the verdict loser can show that it now has critically important evidence that it could not have obtained in time to present at trial, that new evidence may justify granting a new trial. Courts are likely to focus on the importance of the evidence and scrutinize the moving party's justification for failing to obtain it earlier. An inquiry that can raise discovery issues, see Chapter Romans 6. 6. Verdict against the weight of the evidence. Even if there was no demonstrable error in the conduct of the trial, the court may grant a new trial if it concludes that the verdict winner's evidence was so weak that entry of judgment based on the verdict would result in a miscarriage of justice. This standard is not as demanding as the standard for granting a post-verdict judgment as a matter of law, but is relatively close to that standard. 7. Excessive or insufficient verdict. If the amount of damages awarded is either excessive or insufficient, that may be a ground for a new trial. In connection with such a new trial, consider whether a partial new trial limited to determination of the damages could fairly be held. In addition, in cases of excessive damages, consider whether remittiture would be appropriate. In some state courts, but not federal court, additor is permissible when the amount of damages is insufficient. 8. Harmfulness of error. Often, particularly with erroneous rulings on admission of evidence or objections to opposing counsel's conduct during trial, it may be difficult to demonstrate that harmful error occurred. Trials must be fair, but they need not be perfect. The party seeking a new trial must show that the matter raised on the post-trial motion was actually likely to have tainted the result. 9. Conditional ruling on new trial if judgment as a matter of law granted. In federal courts, when both judgment as a matter of law and new trial motions are made, the district court is to make a conditional ruling on the new trial motion, even if it grants the judgment as a matter of law motion, thereby making the new trial issue moot, unless that ruling is reversed on appeal. Right to trial by jury. 1. Source of right. A. Federal courts. 1. Federal Constitution 18843. The Seventh Amendment of the United States Constitution provides, in suits at common law, where the value in controversy shall exceed $20, the right of trial by the jury shall be preserved. This requirement applies to diversity cases regardless of whether there would have been a jury trial if the case had been in state court. Simler v. Connor, 372 U.S. 221 1963. 2. Legislation 18844. In matters not covered by this constitutional provision, there may also be a statutory right to trial by jury when Congress has so provided. B. State courts. 1. No federal constitutional right 1845. Unlike many other Bill of Rights guarantees, the Seventh Amendment right to trial by jury in civil cases has not been held incorporated in the Due Process Clause of the 14th Amendment. Hence, the federal Constitution does not assure such a right in state court proceedings. Walker v. Sovanet, 92 U.S. 90 Wendy 875. Minneapolis and St. Louis Railroad v. Bomboles, 241 U.S. 211 1916. 2. Federal Legislation 18846. However, there may be a federal right to a jury trial in state court actions involving matters governed by federal law, when Congress has so provided. Example: state court civil action based on claim under Federal Employers' Liability Act. See Dice v. Akron, Canton and Youngstown Railroad, 342 U.S. 359 1952. 3. State Constitutions 18847. Also, most state constitutions have provisions similar to the Seventh Amendment that apply to civil actions in state courts. See, e.g., Cal. Const. Art. 1, 16. 2. Cases in which right exists. A. Basic Historical Test 18848. Because the Seventh Amendment and many state constitutional jury guarantees refer to preserving the right to a civil jury trial. A major factor in applying the guarantees is historical inquiry into practice at the time of their adoption. The right to jury trial existed in the English law courts, but not in Chancery, where the system of equity was administered. Accordingly, with a traditional type of claim, a federal court will consider whether the claim is legal or equitable, as such terms were understood in 1791, the year in which the Seventh Amendment became effective. Dimmick v. Skeet, 293 U.S. 474 1934. 1. Jury right after merger of law and equity 18849. With the abolition of separate law and equity court systems in the federal courts and nearly all states, the availability of a jury can no longer depend on the system in which a case is heard. Generally speaking, although with many qualifications, today if a claim would have gone before the law courts before merger, the constitutional jury right applies. If a claim would have been within equitable jurisdiction, there is no constitutional right to trial by jury. 2. Criticism vague distinction 18850. The line between law and equity was somewhat vague and shifting, and depended on the evolution of early English court systems. The main distinction related to the remedy sought. Equity generally afforded remedies such as injunctions that imposed duties directly on the parties, subjecting them to contempt sanctions in the event of disobedience. Law courts, on the other hand, usually afforded monetary damages and other remedies, e.g., ejectment, replevin, that could be enforced by court officers with or without the cooperation of the parties. B. Present federal standards for right to jury trial. 1. Counterparts to actions at law right to jury 18851. Modern actions that are counterparts to actions at law, such as personal injury damage claims or claims to recover damages for breach of contract, are triable to a jury. 2. Counterparts to suits in equity, no right 18852. However, there is no right to a jury in actions that are counterparts to suits in equity, e.g., actions to foreclose mortgages, to enjoin misconduct, or for specific performance of a contract. 3. Statutory remedies 18853. With types of claims that existed when a constitutional guarantee was adopted, the historical inquiry is usually easy and determinative. Legislatures, however, regularly redefine common law rights, replace traditional claims with new forms, and create novel statutory rights. A simple historical test usually cannot resolve the jury right question in such cases, although historical analogies to traditional claims remain a significant factor. A. Statutory substitutes for actions at law 18854. Legislation cannot impair the right to jury trial in federal court. when the right and remedy afforded fit the historical pattern of a judicial proceeding at law. Example: an action to evict a tenant for non-payment of rent is triable to a jury, even when legislation has substituted a statutory remedy for the old common law remedy of ejectment. Purnell v. Southall Realty, 416 U.S. 363, 1974. Example: suits by bankruptcy trustees to recover fraudulent conveyances from parties who had not submitted claims against the bankruptcy estate are quintessentially suits at common law, and Congress could not remove the right to jury trial by assigning jurisdiction over such actions to bankruptcy courts. Grand Financiera, S.A. v. Nordberg, 492 U.S. 33, 1989. 1. Note: federal bankruptcy judges who lack Article Roman III status may conduct jury trials and proceedings within their authority, but only if they are specially designated to exercise such jurisdiction by the district court and with the express consent of all the parties. 28 U.S.C. 157e. 2. But note: proceedings under the Federal Bankruptcy Code are mostly equitable, and a creditor who files a claim against the bankruptcy estate submits to the jurisdiction of the bankruptcy court. Such a creditor cannot insist on a jury trial should the trustee assert a claim to recover a preferential transfer. Langenkamp v. Culp, 498 U.S. 42, 1990. B. When new right involved 1-855. Congress may provide for non-jury trials when the right to be enforced is one not known at common law and practical considerations justify withholding the right to a jury in order to assure efficient disposition, especially if initial adjudication and enforcement of the right are assigned to a federal administrative agency rather than an Article Roman III court. When an action on a new statutory right can be initiated in federal court, the approach in such cases requires examining both the nature of the issues involved and the remedy sought. There is to be a comparison of the statutory action to 18th century, pre-merger English actions, and an examination of whether the remedy sought is legal or equitable in nature. The second remedial inquiry is more important. Chauffeurs, Teamsters and Helpers Local 391 v. Terry, 494 U.S. 558, 1990. Example: Congress could create new duties of employers regarding employee safety and assign disputes to an administrative agency with which a jury trial would be incompatible. Atlas Roofing Co. v. Occupational Safety and Health Review Commission, 430 U.S. 442, 1977. Compare: proceedings to enforce new statutory rights in federal court are triable to a jury when the remedy sought is a legal remedy, such as damages, e.g., claims under federal copyright or civil rights statutes. City of Monterey v. Del Monte Dunes at Monterey, Limited, 526 U.S. 687, 1999. Feltner v. Columbia Pictures Television, Inc., 523 U.S. 340, 1998. Curtis v. Lowther, 415 U.S. 189, 1974. Similarly, an employee who seeks back wages for a union's alleged breach of its duty of fair representation has a Seventh Amendment right to trial by jury in federal court. Chauffeurs, Teamsters and Helpers Local 391 v. Terry, Supra. 1. Civil penalty 1-856. When a statute provides a civil penalty for violation, e.g., a certain amount per day of violation, that is sufficient to create a right to jury trial in an action for a civil penalty. Tull v. United States, 481 U.S. 412, 1987. Action for civil penalties for violation of Clean Water Act. 2. Distinguish amount of penalty 1-857. While holding that there is a right to jury trial with regard to liability for a civil penalty, the Supreme Court has held that there is no right to a jury trial on the amount of the penalty. Tull v. United States, Supra. 4. Actions for declaratory relief 1-858. Actions for declaratory judgments pose special problems because declaratory relief is a statutorily created remedy unknown to early English law or equity, and thus neither legal nor equitable in nature. In general, the federal courts look to what the underlying non-declaratory claim would have been and determine the jury right accordingly. See, e.g., Terrell v. Decana, 877 F2D 1-267 5th Sir. 1989 Declaratory Judgment Plaintiff's Insurance Coverage Claim, if brought for non-declaratory coercive relief, would have been equitable garnishment action. So no jury trial right existed. A. But note, issues in declaratory judgment actions will often be questions of law for the court, rather than of fact for the trier of fact. So no jury right may exist, whether the action would be classified as legal or equitable. 5. Punitive damages 18859. A jury's determination of the amount of punitive damages does not involve fact-finding within the Seventh Amendment. Accordingly, appellate review of a district court's determination that a punitive award is consistent with due process would not involve re-examination of a jury finding of fact forbidden by the Seventh Amendment. Cooper Industries, Inc. v. Leatherman Tool Group, Inc., 532 U.S. 42421. 3. Proceedings in which right to jury applies in part. A. Actions joining legal and equitable claims 18860. Determining whether the right to trial by jury exists on a claim may be only part of the problem. For some cases involve both legal and equitable claims, e.g., a contract action in which a plaintiff seeks damages at law for past breach and an equitable order compelling future specific performance. In general, federal courts are to structure their proceedings to preserve a jury trial on issues common to the legal and equitable aspects of a case. Beacon Theaters, Inc. v. Westover, 359 U.S. 51959. This is usually true, even if the equitable aspects of the case predominate. Dairy Queen, Inc. v. Wood, 369 U.S. 469 1962. Which entirely or virtually eliminates in federal court any modern effect of the old equitable clean-up doctrine that allowed non-jury disposition of minor legal matters in a mainly equitable case. However, the clean-up doctrine survives in some states. 1. Priority of issues at trial 1-861. It may make a great deal of difference which issues in a case are tried first, since adjudication of the issues raised by the equitable claim may render meaningless the claim for legal relief, or vice versa. For example, suppose the plaintiff sues for rescission of a contract for fraud, while the defendant countersues for damages for breach of contract. If the court tries the rescission claim first and holds the contract unenforceable, it thereby disposes of any claim for damages by the defendant. A. State Practice 18862. In state courts, the order of trial is usually within the discretion of the trial judge, who may order either the equitable or legal aspects tried first. B. Federal Practice 18863. In federal courts, however, all issues affecting the claim for legal relief must ordinarily be tried first to the jury. The possibility of irreparable harm to a party from delay in granting an injunction can usually be handled by grant of interlocutory injunctive relief, i.e., a temporary restraining order (TRO) or preliminary injunction, which requires only provisional findings that will not bind the jury or dispose formally of the legal claims. Example: the federal court was not to try equitable claims first in an antitrust case involving a complaint for declaratory judgment and injunction, and a counterclaim and cross-claim for antitrust treble damages, when final determination of common issues between the legal and equitable aspects of the case might prevent the jury trial of the counterclaim and cross-claim. See Beacon Theaters v. Westover, Supra. 1. Erroneous dismissal of legal claims 18864. The Seventh Amendment bars giving preclusive effect to a district court's determinations of issues common to legal and equitable claims when the court resolves the equitable claims first solely because it wrongly dismissed the legal claims. Little v. Household Manufacturing, Inc., 494 U.S. 545 1990. B. Equitable proceedings, seeking legal relief 18865. One historical role of equity was to provide procedural mechanisms for the resolution of complex disputes. Thus, interpleader, class actions, and shareholder derivative suits were inventions of equity. However, in determining the right to jury trial, federal practice now focuses on the nature of the underlying claim, rather than the procedural mechanism by which the claim is to be adjudicated. 1. Shareholder Actions 18866. In a shareholder derivative action in federal court, there is a right to jury trial on all issues that would have been tried by jury if the claim had been brought by the corporation itself. Ross v. Bernhard, 396 U.S. 531 1970. 2. Interpleader 18867. Similarly, an interpleader action would be triable to a jury when the underlying claims against the stakeholder would have been actions at law if brought by the interpleader claimants. Hyde Properties, Inc. v. McCoy, 507 F2D 301 6 Sir. 1974. C. Issues of law and fact bearing on same claim 18868. Even when the right to trial by jury applies, some issues in a case may be questions of law for the judge, while others are issues of fact for the jury. And if the issue of law is dispositive, the case is not decided by the jury. Markman v. Westview Instruments, Inc., 517 U.S. 370 1996 in a patent infringement case. Construction of the patent is a question of law for the judge and may result in judgment as a matter of law against the patent holder, even though whether infringement occurred would be an issue of fact for the jury. 4. Right to jury trial depends on timely demand 18869. Various rules govern the manner in which the right to jury trial must be asserted. Failure to comply with these rules operates as a waiver of the constitutional right. A. State Practice 18870. In state court proceedings, the right to jury trial usually must be exercised by a demand in writing at the time the case is set for trial. Otherwise, the right is waived. 1. Note: if cases are set for trial by request of the parties, e.g., in a motion for trial setting, the demand must be made as part of that request. Where cases are set for trial automatically by the court, the parties ordinarily have a limited period of time after receipt of the notice of trial setting within which to file the written demand for jury trial. Cal. Civ. Proc. Code 631. 2. And note: frequently, a deposit of jury fees is required at the time of jury trial demand. Failure to make the deposit likewise waives the right, although the other party may pick up the tab to preserve a jury trial. B. Federal Practice 18871. In federal actions, when the right to jury trial applies, a party must demand a jury trial in writing with regard to any issue within 10 days of the service of the last pleading directed to that issue. Fed. R. Civ. P. 38b. Ordinarily, parties include the demand as an addendum to their pleadings. Plaintiff demands a trial by jury of all issues triable by jury herein. Example: if defendant's answer contains a counterclaim denominated as such, plaintiff must file a reply to the counterclaim. Fed. R. Civ. P. 7a. If the counterclaim and reply deal with issues as to which a jury trial is available, either party has until 10 days following the filing of plaintiff's reply to demand a jury trial. 1. Amended or supplemental pleadings 18872. The filing of amended or supplemental pleadings does not revive the right to a jury trial if no demand was made when the original pleadings were filed, unless the amended or supplemental pleadings raise new issues that are triable to a jury. 2. Withdrawal of demand 18873. Once a party has timely and properly demanded a jury, the case is to be tried to a jury unless all parties stipulate to trial to the court. Fed. R. Civ. P. 39a. 5. Jury trials discretionary with court. A. When jury previously waived 1-874, the court may order a jury trial on any or all issues in a case in which the right has been waived, e.g., by failure to make timely demand therefor. Fed. R. Civ. P. 39b. B. By consent 1-875. Even when no right to a jury exists, the court may order a binding jury trial with the consent of both parties. Fed. R. Civ. P. 39c. C. Advisory jury 1-876. And the judge may order a trial by jury for the purpose of obtaining an advisory verdict. Fed. R. Civ. P. 39c. C. Cutter Labs v. R.W. Ogle & Co. 151 Cal. App. 2D 410 1957. B. Selection of the jury. 1. Summons of the Venire 1-877. Trial juries are selected from a larger panel of citizens, commonly known as the Venire. Prospective jurors are summoned by the court. A. Historical background on selection 1-878. In earlier times, the clerk or jury commissioner selected Venire men by personal contact. The officer of the court was charged with identifying citizens of good repute to serve as jurors. 1. The key man. Members of the clergy and other professional people known favorably to the clerk or commissioner would frequently be asked to serve as key men to identify appropriate prospective jurors. 2. Talesman. If the court was short of Venire men, the clerk or commissioner might go into the corridors of the courthouse for willing volunteers, known as talesmen. B. Constitutional requirements. 1. Systematic exclusion prohibited 1-879. The systematic exclusion from jury panels of any religious, racial, ethnic, or political group is an unlawful denial of equal protection of the laws. Eubanks v. Louisiana, 356 U.S., 584 1957. And see Constitutional Law Summary. 2. Cross-section, not required 1-880. On the other hand, the Constitution does not require that juries be strictly representative. Jury service may be confined to persons meeting certain standards of education, intelligence, judgment, and character, as long as the standards are not administered in a discriminatory manner. Carter v. Jury Commission of Greene County, 396 U.S., 320 1970. 3. Blue ribbon juries 1-881. Neither does the Constitution prescribe the use of blue ribbon juries selected on the basis of special intelligence or experience to handle complicated cases. Fay v. New York, 332 U.S., 261 1947. C. Contemporary selection practice. 1. Federal courts. A. Local plans 1-882. Jury selection methods in federal courts now conform to plans promulgated by local district courts in conformity with national standards. 28 U.S.C. 1-863. B. Fair cross-section required 1-883. The national policy requires that juries be selected at random from a fair cross-section of the immunity. 28 U.S.C. 1-861. C. Use of voter registration lists 1-884. Every district uses voter registration lists as the basic source from which potential jurors are summoned. Some districts supplement these lists when necessary to foster the national policy above. 28 U.S.C. 1-863b2. 1. When supplementation required 1-885. The voter registration list must be supplemented if it underrepresents any group identified by race, color, religion, sex, national origin, or economic status. 28 U.S.C. 1-862, 1-863b2. D. Challenge to Array 1-886. If the venire has not been selected in strict compliance with statute and the local plan, either party may challenge the array the whole group of prospective jurors and require that a new venire be summoned. 28 U.S.C. 1867C and C. Thiel v. Southern Pacific Co. 328 U.S. 217 1946. 1. Single Non-Representative Panel 1887. It is not a basis for challenging the array that a single panel or venire is not cross-sectional, as long as the method by which the group was selected is random. 2. Non-Representative System 18888. However, if it can be shown that the system regularly produces panels or venires that are substantially non-representative in the same way, this is an adequate basis for challenge. 2. State Courts 18889. Many state courts select juries in a manner similar to the federal system. Others retain vestiges of the traditional practice, and some states continue the use of blue ribbon jury panels supra. 2. Qualifications of prospective jurors. A. Exclusions 18890. Statutes generally provide that certain classes of citizens shall be excluded from juries. Categories typically excluded include minors, felons, aliens, and illiterates. 28 U.S.C. 18865, Cal. Civ. Proc. Code 203. B. Excuses 18891. A prospective juror may be excused for good cause, such as extraordinary financial loss from service. C. 1 day or 1 trial service 18892. Some courts are now summoning jurors to attend court for jury selection for only 1 day or to serve as a juror if selected for only 1 trial. Where this practice is used, exemptions and excuses are likely to be more sparingly recognized. 3. Number of jurors required. A. Typical size of venire 18893. The venire usually consists of at least 2 or 3 times the number of persons who will be selected to serve as jurors. B. Traditional jury of 12 18894. Common law juries were composed of 12 members, and for some time it was assumed that this number was required in federal courts by the 7th Amendment. Capital Traction Co. v. Hoff A. 174 U.S. 11899. C. 12 not required by due process 18895. The common law requirement of 12 jurors has been held not to be required by the Due Process Clause. Williams v. Florida 399 U.S. 78 1970 criminal case. However, due process requires at least 6 jurors in a criminal case. Balu v. Georgia 435 U.S. 223 1978. 1. Civil cases 18896. The minimum number of jurors constitutionally required in federal court civil cases has not been finally resolved. Local district rules providing for 6-member juries in civil cases have been upheld on the rationale that the outcome of the verdict is not likely to be affected substantially by the number of jurors, at least as between 12 and 6. Colgrove v. Batten 413 U.S. 149 1973. 2. State Practice 18897. Since the United States Constitution does not require states to provide jury trials at all, the number of jurors in state court civil trials depends entirely on state law. Many states have long used juries with fewer than 12 members in civil cases, particularly where the amount in controversy is small. D. Jury size in federal court civil cases 18898. Federal Rule 48 provides that the court shall seat a jury of not fewer than 6, nor more than 12 jurors. E. Appointment of alternate jurors 18899. Traditionally, courts appointed alternate jurors in addition to regular jurors to provide for the possibility that a regular juror may be unable to serve for the full term of the trial. Alternates would sit through the trial, but would be excused before the commencement of jury deliberations unless needed to take the place of incapacitated jurors. However, the institution of the alternate juror was abolished for federal courts. Instead, under Rule 48, the court may seat from 6 to 12 jurors. and may excuse some for good cause during trial or deliberations, as long as at least 6 remain, unless the parties agree otherwise. 4. Voir dire examination of jurors 19. After the venire has been initially screened by the court to remove persons who should be excluded, exempted, or excused, the prospective jurors are generally subject to further interrogation about their possible biases. This examination is known as voir dire. A. Challenge for cause 19.1. A party may challenge a prospective juror if it appears that the juror has a financial stake in the case or in similar litigation, if members of the juror's immediate family have such an interest, or if there is other sufficient reason to believe that the juror may be unable to render impartial service. 28 U.S.C. 1866 There is no limit to the number of challenges for cause. B. Peremptory challenge 19.2. Each side is also entitled to a limited number of challenges without a showing of cause, i.e., a peremptory challenge. Rationale. The purpose of the peremptory challenge is to give each side the opportunity to act upon intimations of bias that may not be demonstrable or even rationally explainable. In this way, those persons most distrusted by either side are removed from the jury. 1. Number in federal courts 19.3. In federal courts, each side is entitled to 3 peremptory challenges. 28 U.S.C. 1870. 2. Number in state courts 19.4. The number of peremptory challenges allowed in state court proceedings varies. In California, 6 challenges are allowed, with more permitted in multiparty litigation. Cal. Civ. Proc. Code 231C. 3. Racial grounds for exercise 19.5. The equal protection component of the Fifth Amendment Due Process Clause precludes a private party in federal civil litigation from using peremptory challenges to excuse potential jurors on grounds of their race. Edmondson v. Leesville Concrete Co. 500 U.S. 614 1991. The same rule would apply to state court actions under the 14th Amendment's Equal Protection Clause. 4. Gender grounds for exercise 19.6. The Equal Protection Clause forbids use of peremptory strikes to remove jurors on the basis of their gender. JEB v. Alabama ex rel. TB 511 U.S. 127 1994. C. Questioning by court 19.7. In most jurisdictions, the judge may control the voir dire examination by asking all questions of the jurors. United States v. Cummings 400F. Sup. 2D 822 WD. Pa. 2005. However, the judge must ask all proper questions submitted by counsel in order to enable them to make good use of their peremptory challenges. Butler v. City of Camden 352 F3D 811 3D Sir. 23. 1. Limited to grounds for challenge for cause 19.8. In most jurisdictions, the inquiry on voir dire examination of jurors is limited to grounds that might provide a basis for excusing jurors for cause. See Supra 19.1. In some jurisdictions, however, in criminal cases, counsel are allowed to inquire into any matter that may bear on their exercise of peremptory challenges. D. Questioning by counsel 19.9. Some courts permit counsel to ask questions directly, and in some states, e.g., Texas, counsel have a right to do so. In other states, e.g., New York, the examination may be conducted by counsel outside the courtroom, with the judge called in only to rule on objections. 2. Improper questioning 19.10. It is not proper to use the voir dire examination to put comments or hypothetical evidence before jurors which would not be admissible at trial. If such questioning has been allowed, a new trial should be ordered. Example: where plaintiff is not allowed to offer proof of defendant's insurance at trial, plaintiff's counsel should not be allowed to interrogate prospective jurors about the subject of insurance. 2. Tactic 1911. Counsel may use the voir dire examination as an occasion to preview the case by asking prospective jurors whether they could believe proof of the sort described. or could in good conscience award damages of the amount or type being sought. C. Disqualification of judge. 1. Grounds for disqualification 1912. The judge assigned to a trial proceeding may be disqualified if her impartiality might reasonably be questioned. Bases for disqualification would therefore include the following. See generally 28 U.S.C. 455, Cal. Civ. Proc. Code 171. A. Personal bias 1913. If the judge has a personal bias or personal prejudice concerning a party, she may be disqualified. B. Personal knowledge of the facts 1914. If the judge has personal knowledge of disputed evidentiary facts, she may be disqualified. C. Previous involvement as lawyer 1915. If the judge served as counsel in connection with the controversy, or a lawyer with whom she practiced so served during the period of their association, she may be disqualified. D. Financial interest 1916. A judge may be disqualified if she knows that she, her spouse, or her minor child has a financial stake in the controversy or an interest that could be substantially affected by the outcome. In federal court, corporate parties must file a disclosure statement identifying any related corporations to assist in revealing such an interest. Fed. R. Civ. P. 71. E. Family Relationship 1917. If the judge's spouse or a relative of the judge or the judge's spouse is a party, an officer of a party, or a lawyer for a party, or is known to have a financial interest, or is likely to be a material witness, she may be disqualified. F. Disqualification must be based on extrajudicial matters 1910. The judge's adverse reaction or hostility to the parties, or the evidence generally as a result of presiding over the case, is not a basis for disqualification. Lightke v. United States, 510 U.S., 540 1994. 2. Duty of judge 1919. The judge has a duty to be informed about possible bases for disqualification and to disqualify herself on her own motion if adequate grounds for disqualification exist. 3. Procedure for disqualification. A. Federal Practice 1920. In federal court, a party seeking to disqualify a judge must do so by filing an affidavit of bias, i.e., a sworn statement setting forth the facts that are the basis for disqualification. 28 U.S.C. 144 factual averments in such an affidavit are not open to challenge, except in a criminal proceeding to punish the affiant for perjury. If the facts set forth are legally sufficient to disqualify the judge, she must excuse herself and assign the case to another judge. B. State Practice 1921. State procedures vary greatly. 1. Traditional Rule 1922. Most states require an actual showing by affidavit of grounds for disqualification, as in federal practice. 2. Peremptory Challenge 1923. In some states, each party has an absolute right to disqualify one judge simply by filing, in a timely fashion, an affidavit that he believes he cannot obtain a fair trial before that judge. As to any subsequent judge, a party may make a motion to disqualify and is entitled to a hearing on the facts in front of still another judge, who must determine whether the second should be disqualified. See, e.g., Cal. Civ. Proc. Code 176. However, this system has been criticized as permitting too free an attack on judges and as a source of delay. D. Order of trial. 1. Right to speak first and last. A. General Rule 1924. Ordinarily, the party opening and closing each phase of a trial is the party who has the burden of proof with respect to the principal issues. This usually will be the plaintiff, but it may be the defendant if the plaintiff's prima facie case has been established by the pleadings and pretrial order. B. Discretion of Court 1925. The decision to accord the right to speak first and last is ultimately one for the discretion of the trial judge. Cal. Civ. Proc. Code 607. Court may order different order of presentation for special reasons. 2. Stages of Jury Trial 1926. The usual sequence of a civil jury trial is as follows. A. Opening statement of the plaintiff. B. Opening statement of the defendant. C. Presentation of direct evidence by the plaintiff, with cross-examination of each witness by the defendant, followed by redirect and re-cross-examination. The plaintiff rests. D. Presentation of direct evidence by the defendant, with cross-examination, redirect, and re-cross-examination. The defendant rests. E. Presentation of rebuttal evidence by the plaintiff. F. Presentation of rebuttal evidence by the defendant. G. Argument of the plaintiff to the jury. H. Argument of the defendant to jury. I. Final closing argument of the plaintiff to the jury. J. Instructions to the jury by the judge. K. Verdict of the jury. 3. Non-jury trial 1927. The order of a non-jury trial is essentially the same up to the point at which all evidence has been presented. Before the presentation of argument, or in the course of argument, the parties may propose specific findings of fact and conclusions of law to the court. After the close of arguments, the judge will render the decision, which will take the form of specific findings of fact and conclusions of law. Fed. R. Civ. P. 52A1. E. Presentation of evidence. 1. Control over presentation 1928. Ordinarily, presentation of the evidence at trial is the responsibility of the parties and their counsel, subject to control by the court. Fed. R. Evid. 611A. Even so, most jurisdictions acknowledge the discretionary power of the trial judge to call witnesses on his own motion. In Re Eric A. 73 Cal. App. 4th 1D 390 1999. 2. Rules of Evidence 1929. Proceedings in federal court are governed by the Federal Rules of Evidence. In some respects, these rules incorporate provisions of state law, e.g., what privileges are recognized. Many states have adopted evidence rules that follow the federal rules. Some states, like California, have evidence codes, while others rely in varying degrees on common law rules. See detailed discussion in Evidence Summary. 3. Objections and Exceptions 1930. A. Failure to object 1931. Failure to object to the admission of an item of evidence generally waives the ground for objection. B. Amendment by proof 1932. If no objection is made to evidence that goes beyond the pleadings or the pretrial order to raise new issues, the pleadings or the order will be treated as if they had been amended to allege the facts proved by the evidence admitted. Fed. R. Civ. P. 15b. 16. And C. Supra. 977-992. C. Exceptions unnecessary 1933. In modern practice, it is sufficient to state an objection to the admission of evidence and the basis for the objection. It is not necessary, in order to preserve the issue for appeal, to take exception to rulings on such objections. Fed. R. Civ. P. 46. 4. Burden of producing evidence 1934. The plaintiff must produce sufficient evidence tending to prove each element of the prima facie case. If the plaintiff fails to do so, the defendant is entitled to a dismissal or a judgment as a matter of law at the close of the plaintiff's evidence. Similarly, if a defense is to be considered by the trier of fact, the defendant must produce sufficient evidence tending to prove each element of the defense. Note: a party may be relieved of this burden by the adversary's admissions in pleadings, discovery proceedings, or at pretrial. See Evidence Summary. 5. Judicial Notice 1935. It is unnecessary to plead or prove facts that are not subject to reasonable dispute. The court must take judicial notice of such facts. See Evidence Summary. F. Pre-verdict motions. 1. In General 1936, at the close of proof, motions may be used to determine whether a party has carried the burden of producing evidence, e.g., motion for judgment as a matter of law for non-suit, or for involuntary dismissal. 2. Jury trial motion for judgment as a matter of law directed verdict 1937. In a jury trial, either party may move for judgment as a matter of law when the adversary has been fully heard with respect to the issue in question. Fed. R. Civ. P. 50a. Some courts have developed acronyms for this motion. See, e.g., Weiss v. Schuckman. 98 F3D 542 10th Sir. 1996 JML. McKeel v. City of Pine Bluff. 73 F3D 207 8th Sir. 1996 JAML. A. Terminology 1938. Before Federal Rule 50A was amended in 1991. What is now called a motion for judgment as a matter of law was called a motion for a directed verdict. State courts usually still refer to such a motion as a motion for directed verdict. B. Standard for grant 1939. The general standard for whether to grant a motion for judgment as a matter of law looks to whether there is a legally sufficient evidentiary basis on which the jury could find for the non-moving party. The application of this standard depends on whether the moving party has the burden of proof on the issue raised. 1. Moving party with burden of proof 1940. If the moving party has the burden of proof, judgment as a matter of law is appropriate only if the evidence favoring the moving party is of such compelling strength that the jury could not reasonably find for the opposing party. Accordingly, to defeat the motion, it is sufficient that the jury could reasonably disbelieve the witnesses upon whom the moving party relies. A. State Court View 1941. In some states, a directed verdict cannot be entered if the movant has the burden of proof unless the facts are totally uncontroverted or the parties agree to them. Allstate Insurance Co. v. Miller, 553 A2D 1268 MD, 1989. 2. Opposing party with burden 1942. If the party moving for judgment as a matter of law does not have the burden of proof, the motion should be granted only if the opposing party has no substantial evidence to permit a jury reasonably to find in its favor. A. Scintilla Rule contrasted 1943. In some jurisdictions, the scintilla rule still is invoked. Under this rule, a party with a scintilla of evidence would be allowed to have her case presented to the jury. The federal courts have rejected the scintilla rule. Galloway v. United States, 319 U.S., 372 1943. C. Case-by-case determination 1944. The court's evaluation process must be made on a case-by-case basis, and discussion of given cases should involve careful examination of the facts presented and inferences from them. As a consequence, it is difficult to present rules governing judgment as a matter of law. There are, however, a number of governing principles that are helpful in analysis, and these are discussed below. 1. All reasonable inferences indulged in favor of opposing party 1945. The court is to make all reasonable inferences in favor of the opposing party, and to view the evidence in the light most favorable to that party. 2. Court may not weigh evidence 1946. The court is to determine whether there is a genuine issue to present to the jury. It may not choose between two versions of events and grant judgment as a matter of law to the party whose version seems more persuasive. A. Role of speculation 1947. Within limits, the fact that the jury's decision will involve some speculation is not a ground for taking the case from the jury. If facts are in dispute or reasonable people may draw different inferences from the evidence, the jury may use speculation and conjecture to settle the dispute by choosing what seems to be the most reasonable inference. Lavender v. Kern, 327 U.S., 645 1946. B. Equal Possibilities Analysis 1948. It is sometimes said that the case should be taken from the jury when the evidence presented on any essential fact by the party with the burden of proof shows only an equal possibility of the existence of that fact. See, e.g., Pennsylvania Railroad v. Chamberlain, 288 U.S., 333 1933. This analysis has been rejected in most jurisdictions, as long as there is some basis on which the jury could choose between conflicting versions of events. 3. Evidence to be considered. A. Only opposing parties' evidence. 1949. Some courts limit their examination to the evidence offered by the opposing party, at least in cases where the opposing party has the burden of proof, and the courts may say that the moving party's evidence is irrelevant. Lavender v. Kern. Supra defendant's evidence was irrelevant upon appeal, there being a reasonable basis in the record to support the jury's verdict for plaintiff. B. All evidence presented in light most favorable to opposing party. 1950. The federal rule is that the court should review the record as a whole, but it must disregard all evidence favorable to the moving party that the jury is not required to believe. Reeves v. Sanderson Plumbing Products, Inc., 530 U.S., 133 2000. 4. Demeanor evidence. 1951. The jury has observed the witnesses while testifying and may draw conclusions about their truthfulness from their demeanor. A. Moving party with burden of proof. 1952. If the moving party has the burden of proof and relies on witnesses whom the jury could disbelieve, it is not entitled to a judgment as a matter of law, even if there is no conflicting evidence offered. See Supra, 1940. 1. Possible exception. Disinterested. Unimpeached witness. 1953. The above rule may not apply if the witness relied upon is disinterested and has not been impeached. Under these circumstances, there may be no reasonable basis for disbelieving the witness. See Lundeen v. Cordner, Supra, 1752. Example: plaintiff, the executor of decedent's estate, sues defendant, the executor of driver's estate, to recover for decedent's injuries in the head on automobile collision in which both were killed. The physical evidence at the scene of the accident does not show who drove over the center line and caused the accident, but plaintiff charges that driver drove over the line and must prove this fact to collect. Plaintiff relies on the testimony of a highway patrol officer that she was driving behind driver's car and observed driver drive across the center line and collide with the car driven by decedent. There are no other witnesses and no other evidence, and the officer is not impeached in any way. Plaintiff should be granted a judgment as a matter of law. 2. Opposing party with burden of proof. 1954. Demeanor evidence, sometimes called disbelief evidence, is not sufficient to satisfy the opposing party's burden of producing evidence. Dyer v. McDougall, Supra, 1709. 5. Distinguish renewed motion for judgment as a matter of law. Judgment NOV, 1955. If a motion for judgment as a matter of law is made before a verdict is rendered, but is denied and the verdict goes against the moving party, the party may make a renewed motion for judgment as a matter of law, formally called a judgment NOV, see infra, 2034-2047. Whether resolved before or after the verdict, the motion uses the same standard, and thus asks the same question at different times whether the case should be or should have been submitted to the jury. A. Pre-verdict motion as predicate for renewed motion. 1956. In federal court, a party may not make a renewed motion unless she moved for a judgment as a matter of law after the opposing party was fully heard on an issue and before submission of the case to the jury. Fed. R. Civ. P. 50b. 1. Constitutional justification. 1957. This requirement of a pre-verdict motion is a result of the Supreme Court's early decision that the judgment NOV, renewed motion, violated the right to jury trial. Slocum v. New York Life Insurance Co., 228 U.S., 364 1913, which the court modified to permit a renewed motion if there was first a directed verdict motion on which the judge reserved ruling. Baltimore and Carolina Line v. Redmond, 295 U.S., 654 1935. Thus, Rule 50b states that whenever there is a motion for judgment as a matter of law, the judge will be deemed to have reserved later ruling on it to satisfy Redmond. 2. Opportunity to cure deficiencies in proof 1958. Some argue that the requirement of a predicate motion for a directed verdict permits parties to cure omissions from their proof before the case is submitted to the jury, and that there is good reason to give parties an incentive to call such problems to the attention of the other side. 3. Timing of motion 1959. Until it was amended in 2006, Rule 50B permitted a post-verdict motion for judgment as a matter of law only if the moving party made such a motion before the verdict, at the close of all the evidence. The rule now requires only that the pre-verdict motion be made after the opposing party has been fully heard on the issue raised by the motion, which may be much earlier in the trial, perhaps even before the opposing party has completed offering all its proof in the case. B. Deferring decision until after verdict 1960. Judges presented with motions for judgment as a matter of law may consider a variety of factors, including the following, in deciding whether to defer decision when they find the motions persuasive. 1. Jury will agree 1961. If the judge feels that one side's case is so weak that judgment as a matter of law is proper, it is likely that the jury will also feel that way, and a jury verdict to that effect will be harder to overturn on appeal. 2. Judge may be wrong 1962. If the judge grants judgment as a matter of law and is reversed on appeal, it will be necessary to hold a second trial, whereas the appellate court may be able to reinstate the jury verdict if it reverses a post-verdict decision to grant judgment as a matter of law, and avoid thereby the need for a retrial. 3. Time savings 1963. By granting a pre-verdict motion for judgment as a matter of law, the judge saves the time that would be needed for the rest of the trial. At a minimum, granting the motion can save the time required for closing arguments to the jury, the judge's instructions to the jury, and jury deliberations. But there may be even greater time savings depending on when the motion is made. In federal court, the motion can be made when the opposing party has completed its proof on a given issue. For a motion by the defendant, this could be before the plaintiff has even finished its case in chief. Granting the motion in such a case would avoid the time needed for the remainder of the plaintiff's case in chief, for the defendant's case in chief, and for all rebuttal evidence. 3. Jury trial motion for non-suit 1964. In some states, the defendant may move for a non-suit at the close of the plaintiff's opening statement or at the close of plaintiff's proof. A. Test applied 1965. Such a motion should be granted if the opening statement or proof reveals the plaintiff's case to be legally insufficient. For example, the plaintiff's failure to produce any credible evidence of damages might justify a non-suit in a negligence case. Sevel v. Hines, 116a, 919 pa. 1922. B. Judgment on merits 1966. Historically, a judgment of non-suit was not a judgment on the merits, and thus did not bar a new action on the same cause. Oskanian v. Arms Co., 103 U.S., 261 1880. However, this rule has been changed in most states by legislation or court rule. Cal. Civ. Proc. Code 581 cc. 4. Non-jury trial motion for judgment as a matter of law 1967. In a non-jury trial, after any party has been fully heard with respect to an issue, the court may enter judgment as a matter of law against that party on that issue. Fed. R. Civ. P. 52c. A. Early Common Law Treatment 1968. The historical analog to this motion was a demurrer to the evidence, which required the trial judge to accept all of the plaintiff's evidence as true for the purpose of ruling on the demurrer. B. State Practice 1969. Nomenclature for this motion varies among the states. In some, it is referred to as a motion to dismiss, while in others it is a motion for judgment. Cal. Civ. Proc. Code 631-8 Motion for Judgment. C. Test applied 1970. Under modern practice, the court may grant the motion if it finds that the plaintiff's proof is unpersuasive on issues as to which plaintiff had the burden of persuasion. Huber v. American President Lines, 240 F2D 778 2D Sir. 1957. The rationale is that, in a non-jury trial, the judge is the ultimate trier of fact, and if she is already convinced, there is no reason to require further proof by the defendant. G. Argument to jury. 1. Time for argument 1971. In federal and most state courts, counsel's argument to the jury takes place at the close of the evidence and before the judge instructs the jury, so that the last words the jurors hear are those of the judge, rather than the impassioned pleas of counsel. Fed. R. Civ. P. 51. 2. Right to argue 1972. Counsel have an absolute right to argument in a jury trial. Nishihama v. City and County of San Francisco, 93 Cal. App. 4th 298 2001. 3. Control of argument by court 1973. However, the trial judge in his discretion may control the duration and manner of argument. 4. Limitations on argument 1974. In arguing to the jury, counsel is subject to the following constraints. A. Comment must be based on the evidence, and counsel may not distort the facts or assume facts not in evidence. B. Argument must be within the limits of the substantive law governing the action. Thus, for example, counsel may not argue for the use of an improper method of calculating damages, e.g., to punish a defendant in an ordinary negligence case. C. Counsel may not appeal to the passions or prejudices of the jurors. Pingatter v. Montgomery Ward & Co., 419 F2D 1N138 6th Sir. 1969. However, less restraint is imposed on counsel when the dispute is one fraught with emotion, such as a defamation trial. Curtis Publishing Co. v. Butts, 351 F2D 702 5th Sir. 1965. 5. Effect of improper argument 1975. Not every improper argument requires a reversal of the judgment obtained and a new trial. A new trial is in order only if the argument is not adequately corrected by the judge, so that an incorrect verdict is likely to have resulted. H. Instructions to jury. 1. In general 1976. Before a case is submitted to the jury for a verdict, the trial judge instructs the jury on certain relevant matters. 2. Issues of fact 1977. The jury's role is to decide issues of fact identified by the judge in the instructions, whereas the judge must decide questions of law, such as the meaning of statutes and documents. A. Law vs. Fact 1978. Issues of law can be said to be general and to pertain to interpretation of the controlling law, while issues of fact are specific and pertain to past events. However, the boundary between the two may be unclear at times, in which case the matter must be resolved by reference to historic policy regarding the role of the jury. Example: the law of negligence is usually expressed in general terms, e.g., a failure to exercise reasonable care, that minimize the role of the judge in defining the issues and maximize the role of the jury in deciding cases. Compare: if a decision necessarily requires that some additional meaning be attributed to the legal standard by the jury applying it, a law issue is inevitably intertwined with a fact issue, and such matters are sometimes said to present a mixed issue of law and fact. See Wiener, The Civil Jury Trial and the Law-Fact Distinction, 54 Cal. L. Rev. 18867 1966. B. Jury decides disputed facts, only 1979. There is an issue of fact for the jury only if there is a genuine dispute about past events or the interpretation of those events. 1. Facts not in dispute 1980. If only one reasonable inference can be drawn with respect to a matter, the judge should give instructions that assume the necessarily inferred fact. Thus, in a contract dispute in which a written contract is proved, and the evidence presented by the defense bears only on the amount of damages, the court should not ask the jury to decide whether there was mutual assent. 2. Disputed facts 1981. The judge may not give an instruction that assumes a fact in dispute. Each party is entitled to have the jury instructed to consider her version of matters that have been disputed. For example, if the defendant in a contract dispute offers proof tending to show that the written contract presented by the plaintiff was not signed by the defendant, the court must put the issue of mutual assent to the jury, however much the judge may doubt the denial. 3. Burden of persuasion. A. Assigning the burden 1982. The judge must explain to the jury which party has the burden of persuasion in regard to each issue of fact that the jury must decide. The burden of persuasion will generally be assigned to the party having the burden of producing the evidence in regard to that issue. But this may not be the case if there is an applicable legal presumption. See Evidence Summary. B. Degree of persuasion. 1. Preponderance of the evidence 1983. In a civil case, the trier of fact usually must be persuaded that a fact is more probable than not in order to resolve an issue in favor of the party bearing the burden of persuasion. Sullivan v. Nesbitt, 117a, 502 Con. 1922. 2. Clear and convincing proof 1984. In regard to issues of fraud, duress, or undue influence, however, the trier of fact generally is instructed to find for the party having the burden of persuasion only if the evidence is clear and convincing. This rule evolved in equity, which was said to presume honesty and fair dealing, thus requiring a greater amount of evidence to overcome the presumption. A. Note rejected by some modern courts 1985. Some modern courts have rejected this principle, holding that a mere preponderance is sufficient with respect to any issue in a civil case. Weiner v. Fleischman, 54 Cal. 3D 476 1991. 4. Comment on the evidence. A. Majority Rule 1986. In most courts, the judge is allowed to comment on the quality of proof, which bears on issues that the jury must decide, provided she informs the jury that it is the final decision-maker. Acevedo Garcia v. Monroig, 351 F3D 547 1st Sir. 2003, Cal. Const. Art. Roman 6, 10. B. Minority Rule 1987. Some states do not permit any comment on the evidence, on the ground that a judge's comments are too likely to prejudice the jury. 5. Instructions requested by counsel. A. Responsibility for preparation 1988. While the ultimate responsibility for instructions rests with the judge, counsel has the duty of proposing instructions that present her theory of the case. Fed. R. Civ. P. 51A. Wilden v. Washington National Insurance Co. 18 Cal. 3D 631 1976. B. Form of Requests 1989. Proposed instructions must be in writing and must be served on opposing counsel. C. Time for filing 1990. The federal rules provide that requests for instructions must be filed at the close of the evidence or at such earlier time as the court reasonably requires. Fed. R. Civ. P. 51A. In a complex case, the judge often orders such proposals to be filed before trial at the time of pretrial conference. 1. State practice may vary 1991. In California, for example, instructions covering the legal issues raised by the pleadings must be filed before the first witness is sworn. Cal. Civ. Proc. Code 607A. D. Objections 1992. Each party must be given the opportunity to object to instructions proposed by his adversary. Failure to make objection before the jury retires is generally a waiver of any error not pointed out to the judge. Fed. R. Civ. P. 51C2. E. Notice to counsel of court's action on requests 1993. Before counsel make their arguments to the jury, They are entitled to be informed of the judge's rulings on their requests for instruction. Fed. R. Civ. P. 51b1 Rationale. Counsel need to know what the judge will say during instructions, so that they can structure their closing arguments accordingly. 6. Appellate review of jury instructions. A. Plain error 1994. Ordinarily, any error in the jury instructions is waived unless a timely objection was made in the trial court, see above. A federal trial or appellate court may, however, consider a plain error in the instructions that has not been preserved as required, if the error affects substantial rights. Fed. R. Civ. P. 51d2. B. Harmless error 1995. On the other hand, if it appears unlikely that the jury was misled by a minor error in instructions, the error may be deemed harmless. Fed. R. Civ. P. 61. Cal. Civ. Proc. Code 4075. In applying this rule, the appellate court will consider the impact of the instructions as a whole. Marshall v. Ford Motor Co. 446 F2D 712 10th Sir. 1971. 1. Note. Where alternative theories are advanced, the instructions given are correct as to one theory but incorrect as to the other, and the jury returns a general verdict with no indication as to which theory was accepted. Reversal is generally required, because there is no certainty that the error was harmless. Pacific Greyhound Lines v. Zane, 160 F2D 731 9th Sir. 1947. 2. But note, a minority of courts adheres to the principle that a jury should be presumed to have based its verdict on the correct portion of the instruction. State v. Hills, 113 NE, 1945, Ohio, 1916. I. Jury deliberation and verdict. 1. Types of verdicts 1996. Verdicts may take several forms, depending on the form of jury instructions. A. General verdict 1997. The traditional and still most common form of verdict is the general verdict, in which the jury simply makes a decision in favor of one party or the other. Such a verdict implies a finding in favor of the prevailing party on every material issue of fact submitted to the jury. Cal. Civ. Proc. Code 624. Example. In the typical negligence case, a general verdict for the plaintiff necessarily rests on finding that the defendant was negligent, that the negligence proximately caused harm to the plaintiff, and that the plaintiff was free of contributory negligence. Sassano v. Rallard, 27 Cal. App. 2D 372 1938. 1. Criticism. At the same time, a general verdict may conceal a misunderstanding of the instructions or even a disregard of them. It has been called the great procedural opiate because it draws the curtain upon human errors and soothes us with the assurance we have attained the unattainable. Sunderland, Verdicts, General and Special, 29 Yale LJ, 253 1920. B. Special Verdict 1998. A special verdict consists of the jury's answers to specific factual questions that it is instructed to decide. In this situation, the jury does not decide directly which party should prevail on the law. Instead, the special verdicts should resolve all the material issues so the court can enter judgment. Fed. R. Civ. P. 49A1. Cal. Civ. Proc. Code 624. 1. Verdicts required on all disputed issues 1999. To serve their purpose, special verdicts should usually be fashioned to cover all disputed issues so that the judge can determine the proper judgment from them. 2. Advantages 2000. A special verdict reduces the burden on the judge of instructing the jury on the law and reduces the jury's need to understand the law. 3. Disadvantages 2001. If a special verdict is used, the jury may find it harder to reach a unanimous verdict. Moreover, inconsistent findings on a crucial issue may necessitate a new trial. However, The court has the power to interpret the jury's findings in order to mold them to a judgment. Gallick v. Baltimore and Ohio Railroad, 372 U.S., 108 1963. 4. Disclosure to counsel 2002. Some courts hold that counsel should be given access to the special verdicts and an opportunity to comment on them. Sakamoto v. NAB, Trucking Co., 717 F2D 116 Sir, 1983. Clegg v. Hardware Mutual Casualty Co., 264 F2D 152 5th Sir, 1959. 5. Advising jury of legal consequences of answers 2003. Since the judge is to draw the legal conclusions from the special verdicts, it is not required that the jury be instructed on them. However, the district court may decide to inform the jury. Buell v. AC International, Inc., 233 F3D 441 7th Sir, 2000. It would be difficult to conceive that a judge's decision to provide a jury with legal information could constitute reversible error rationale. The jury is likely to deduce from the lawyer's arguments which party will be benefited from a particular resolution of an issue, and so the judge should have the right to make it clear to the jury. C. General Verdict with Special Interrogatories 2004. The trial judge may combine the two foregoing forms of verdict by instructing the jury to return a general decision as to which party should prevail on the law, while simultaneously answering specific questions of fact posed by the evidence. Fed. R. Civ. P. 49B1. Cal. Civ. Proc. Code 625. 1. Purpose 2005. The idea of this combined form of verdict is to permit the jury to decide the whole case, while obtaining a cross-check that the jury understood and adhered to the instructions on the law. 2. Disadvantage 2006. Like special verdicts, the general verdict with special interrogatories carries the risk of inconsistency necessitating a new trial. A. Inconsistency between finding and verdict 2007. If there is an inconsistency between the special finding and the general verdict, the judge in her discretion may disregard the general verdict and enter judgment according to the special findings. Fed. R. Civ. P. 49B3A. Cal. Civ. Proc. Code 625. B. Inconsistency among findings 2008. However, if there are inconsistencies among several of the special findings, the judge must order a new trial unless she can reconcile the inconsistencies. In doing so, there is a presumption in favor of the general verdict, and special findings should be reconciled so as to support the general verdict, if possible. Law v. Northern Assurance Co., 165 Cal. 394 1913. 3. Failure to respond 2009. Failure to respond to a special interrogatory is not necessarily fatal to the verdict. The court in its discretion may assume that the missing answer would be consistent with a general verdict. Gulf Refining Co. v. Fetchen, 130 F2D 129 6 Sir, 1942, Cert. Denied, 318 U.S., 764 1943. 4. Inability to agree on an issue 2010. And even where the jurors announce their inability to agree on a particular issue, the verdict may be sustained if there is agreement on an alternative finding sufficient to support the general verdict, e.g., jurors could not agree on which among several negligent acts by defendant caused plaintiff's injury, but agreed that one of those acts was responsible. But see Jazabi v. Allstate Insurance Co., 278 F3D 9 and 79 9th Sir, 2002 to hold defendant liable. Jury must unanimously reject affirmative defense. 2. Requirement of unanimity. A. General Rule 2011. In federal and most state courts, the jury must render a unanimous decision, unless the parties otherwise agree. Fed. R. Civ. P. 48. 1. Purpose 2012. This requirement forces the jurors to deliberate in any case in which one of the group has serious doubt about the outcome. 2. Dynamite charge 2013. If the jurors, after deliberating, announce that they are unable to reach a verdict, it is not improper for the court to emphasize to the jury the expense of a new trial and the unlikelihood that another jury would reach a better verdict, and to ask each juror to make a renewed effort to reach unanimity. Allen v. United States, 164 U.S. 492 11896. Such a charge is sometimes referred to as a dynamite charge. B. Minority Rule 2014. Some states permit non-unanimous verdicts. In California, for example, only 3/4 of the jury in civil cases must concur. Cal. Civ. Proc. Code 618. C. Tactic 2015. The unanimity requirement generally favors the defense, at least insofar as the plaintiff has the burden of persuasion on the disputed issues. Thus, if non-unanimous verdicts are allowed in state court, the plaintiff may prefer to litigate there, whereas the defense may seek to remove to a federal court. 3. Jury deliberation and impeachment of verdict. A. Standards of jury conduct. 1. Materials taken into Jury Room 2016. In its deliberations, a jury normally has access to exhibits or other papers received in evidence. Cal. Civ. Proc. Code 612. The judge may allow jurors to take notes during the trial, and such notes may also be used during deliberations. 2. Consideration of matters outside the record 2017. The jury is not permitted to receive any information that was not presented at trial and made a part of the record. A. Any communication from the judge must be received in court in the presence of counsel. Cal. Civ. Proc. Code 614. For example, it is error for the judge to provide the jury with a dictionary in counsel's absence, where it appears that jurors may use the dictionary definition of important terms in arriving at their verdict. Palstroni v. Jacobs, 77A2D 183 NJ, 1950. B. It is improper for jurors to fraternize with counsel during the trial or during deliberation. C. And it is likewise improper for the jury to conduct its own investigation of the facts by calling experts in the absence of counsel, conducting experiments with the exhibits, or independently taking a view of the premises of an accident. Sopp v. Smith, 59 Cal. 2D 12 1963. 3. Each juror shares in decision 2018. Consistent with the requirement of unanimity, each juror must make up her own mind on the verdict. A. Chance verdicts 2019. Accordingly, the jury may not decide by lot or other method of chance. Cal. Civ. Proc. Code 16572. B. Quotient verdicts 2020. Nor may the jury reach a decision by taking an average of several awards of the jurors. Such an average may be computed as a means of assisting each juror to appraise the appropriate award, but the jurors may not bind themselves in advance to the result of the computation. See McDonald v. Pless, 238 U.S. 264 1915. C. Coercion by Judge 2021. The judge may not coerce the jury to agree. In this regard, it may be reversible error to repeat a dynamite charge. See Supra, 1939, urging unanimity. United States v. Nickel, 883 F2D 824 9th Sir. 1989. B. Impeachment of verdict for misconduct. 1. Common Law Rule 2022. The traditional common law rule was that a juror could not impeach his own verdict. Thus, any misconduct in the deliberation had to be established by the testimony of someone other than the jurors, such as a bailiff or court attendant. A. Rationale. This rule safeguarded the secrecy of jury deliberations and protected jurors from harassment by counsel urging repudiation of verdicts. See McDonald v. Pless, Supra. B. Criticism. At the same time, The rule made enforcement of the standards of conduct described above very difficult. 2. Federal Rule 2023. The federal rules of evidence now permit a juror to testify to any extraneous prejudicial information or outside influence that may have altered the verdict. Fed. R. Evid. 606b. A. Scope 2024. This rule does not authorize the use of juror testimony to attack the deliberative process matters occurring inside the jury room, as by showing a quotient verdict. See Skajan v. Century Fitness, Inc., 780 F2D 1316 8th Sir. 1985. It is possible, however, to use juror testimony to show gross misconduct, such as taking of a bribe or fraternizing with a party. See, e.g., Jorgensen v. York Ice Machinery Corp., 160 F2D 432 2D Sir. 1947. Example: use of intoxicants. Where jurors drank heavily during lunch, some smoked marijuana or took cocaine during the trial, and jurors generally approached their task as one big party, juror affidavit was inadmissible to impeach the verdict on these grounds, because they were internal to the verdict. Tanner v. United States, 483 U.S., 107 1987. B. Distinguish determining what was decided for issue preclusion purposes 2025. The rule of exclusion applies to challenges to the validity of a verdict, but does not forbid use of juror affidavits to determine what was actually decided in order to give proper issue preclusion effect to the verdict. For discussion of issue preclusion, see Infra 2304 at Sec. 3. State Rules 2026. Some states are much more permissive than the federal courts with respect to use of juror testimony to attack verdicts. In California, for example, any improper influence inside or outside the jury room may be shown. People v. Hutchinson, 71 Cal. 2D 342 1969. Example: juror testimony may be used to show that jurors were coerced to change their views, or that improper consideration was given to the fact of insurance. A. Rationale. Assuring the purity of a verdict is more important than protecting its stability. B. Limitation. However, affidavits may not be used merely to show that a juror's reasoning or mental process was faulty. C. Impeachment of verdict for inaccurate response on voir dire 2027. A juror's failure to respond correctly to voir dire may be a ground for impeaching the verdict. 1. Showing required 2028. The party challenging the verdict must show that the juror refused to answer honestly a material question, and that a correct response would have provided a valid basis for challenge for cause. McDonough Power Equipment, Inc. v. Greenwood, 464 U.S., 548 1984. Example: a juror in a personal injury case was asked whether any member of his family had suffered injuries that resulted in any disability or prolonged pain or suffering. He failed to reveal that his son had once been injured due to explosion of a truck tire, but because the juror honestly did not understand that describing this event was called for by the question, his failure to answer did not provide a ground to set aside the verdict. McDonough Power Equipment, Inc. v. Greenwood, Supra. 2. Contempt 2029. When a juror intentionally withholds disqualifying information, he may be held in contempt for doing so. Clark v. United States, 289 U.S., 1 1932. D. Announcement of Verdict 2030. To help ensure that deliberations were proper, the jury verdict must be announced in open court. 1. Polling the jury to wing 31. At the request of either party, the jury may be polled, i.e., each juror may be asked if he concurred in the verdict. If a juror fails to concur, the jury must continue its deliberations or a new trial must be ordered. Fox v. United States, 417 F2D 84 5th Sir. 1969. 2. Correction of Verdict 2032. Likewise, If the verdict returned is insufficient or incomplete, the court may direct the jury to continue and complete its deliberations. Cal. Civ. Proc. Code 619. A. But note, once the jury is discharged, a defect in the verdict cannot be cured. Mendoza v. Club Car, Inc., 81 Cal. App. 4th 287 2000. E. Investigation of Jury Misconduct 2033. Counsel may question jurors after they have given their verdict in order to ascertain any possible basis for impeachment. 1. Limitation. However, hostile interrogation of jurors may be enjoined. Rakes v. United States, 169 F2D 739 4th Sir. 1948. And some courts routinely limit post-trial interrogation of jurors. 2. And note, jurors cannot be subpoenaed unless there is some reason to expect that their testimony may reveal a ground for impeachment. The rationale is that jurors should not routinely be subject to being placed on trial by defeated litigants. Linhart v. Nelson, 18 Cal. 3D 641 1976. J. Motions after verdict or judgment. 1. Renewed motion for judgment as a matter of law judgment, notwithstanding the verdict 2034. Judgment non obstant verdicto NOV or notwithstanding the verdict is a traditional device for nullifying a jury verdict that is not supported by the evidence. In 1991, the name was changed in federal court to renewed motion for judgment as a matter of law. Fed. R. Civ. P. 50B. A. Test applied 2035. The standard applied for a renewed motion is the same as for such a motion at the close of all the evidence, i.e., the motion should be granted only if there is no substantial evidence to support the decision of the jury. Montgomery Ward & Co. v. Duncan, 311 U.S., 243 1940 C. Supra, 1928-1954, regarding standard on motion before the verdict. B. Procedural requirements. 1. Motion 2036. In federal court, a renewed motion for judgment as a matter of law may not be entered by the court on its own motion. If no motion is made, not even an appellate court has power to enter judgment for the losing party. Cone v. West Virginia Pulp and Paper Co., 330 U.S., 212 1946. A. Some states contra 2037. In at least some states, judgment can be entered sua sponte. Cal. Civ. Proc. Code 629. 2. Timeliness of motion. A. Federal Rule 2038. In federal court, a renewed motion for judgment as a matter of law must be made within 10 days after the entry of judgment on the verdict. Fed. R. Civ. P. 50B. B. State Practice 2039. Time limits in state practice may vary. Cal. Civ. Proc. Code 629 15 days following notice of entry of judgment. 3. Prior motion for judgment as a matter of law 2040. In federal court, a motion for renewed motion for judgment as a matter of law cannot be considered unless the moving party made a motion for judgment as a matter of law after the opposing party had been fully heard on the issue raised by the motion. Fed. R. Civ. P. 50B. A. Rationale 2041. Judgment NOV was not known at common law, and hence presumably was forbidden by the Seventh Amendment. But a directed verdict was permitted at common law, and since the judge can reserve his ruling on that motion, a motion for judgment NOV can be viewed as a renewal of the motion for a directed verdict. Baltimore and Carolina Line v. Redmond, Supra, 1957. B. State Practice Contra 2042. Most states do not require a prior motion for directed verdict in order to move for judgment NOV. Cal. Civ. Proc. Code 629. 4. Joined with motion for new trial 2043. A post-verdict motion for judgment as a matter of law may be joined with a motion for new trial. B. If judgment granted 2044. If judgment as a matter of law is granted, the trial court should nevertheless rule in the alternative on the motion for new trial. In that way, if there is an appeal, the appellate court will have full knowledge of the trial judge's decision. Fed. R. Civ. P. 50C1. B. If judgment denied. 1. Appeal 2045. The party whose motion is denied may appeal from the judgment as entered, but not from denial of the motion, which is a non-appealable order. See Infra 2170 at Sec. 2. Responding party's ground for new trial 2046. If the moving party does appeal, the party seeking to preserve the verdict should assert in the alternative any grounds he may have for a new trial. Otherwise, the issues may not be preserved for consideration by the appellate court, which might reverse and order entry of judgment contrary to the verdict. Fed. R. Civ. P. 50E. And C. Neely v. Martin K. Ebby Construction Co. 386 U.S. 317 1967. 3. Appellate court may enter judgment for verdict loser 2047. If a federal appellate court determines that some trial evidence was erroneously admitted and that the remaining evidence did not suffice to put the case before the jury, it may direct entry of judgment as a matter of law for the verdict loser. Wisegram v. Marley Co. 528 U.S. 442,000. 2. Motion for new trial 2048. The trial judge has the power to order a new trial on all or part of the factual issues in dispute. Fed. R. Civ. P. 59A1. Cal. Civ. Proc. Code 657. A. Grounds for motion jury trial 2049. A federal court may order a new trial in a jury case for any reason for which a new trial has heretofore been granted in an action at law in federal court. Fed. R. Civ. P. 59. A1. Some state statutes are more explicit in enumerating grounds. Cal. Civ. Proc. Code 657. In any case, appropriate grounds would include the following. 1. Prejudicial misconduct 2050. A new trial may be granted if the court, the jury, or the adversary engaged in misconduct that prevented a fair trial. Example: counsel's improper jury argument was a basis for granting a new trial. Minneapolis, St. Paul and Sault Ste. Marie Railway v. Mockwin, 283 U.S. 520 1931. Example: a false answer by juror on voir dire examination allowed for a new trial. Estate of Messner, 77 Cal. App. 2D 667 1947. Example: an improper delay or continuance for personal convenience of the trial judge was also a basis for a new trial. Citron v. Aero Corp. 377 F2D 753D Sir. 1967. A. No new trial for harmless error 2051. A new trial should not be ordered for misconduct that was not prejudicial or was adequately corrected by appropriate instructions from the judge. Fed. R. Civ. P. 61. B. Waiver of prejudicial error 2052. And a party moving for a new trial may not rely on misconduct known to him before the verdict, but which he did not point out to the court. Rationale: allowing the party to gamble on the outcome of the verdict would impose an unfair risk on the adversary, who would be faced with the alternative of an adverse verdict or a new trial. Decado v. Goner, 73 NE2D 1942 Ohio 2000. 2. Accident or surprise 2053. A new trial may be granted when a party is unfairly surprised by the evidence presented at trial. A. Prejudicial effect 2054. The surprise must have had a material effect on the outcome of the trial. Dostal v. Curran, 679 NW2D 192 Min. 24. B. Diligence 2055. The party also must have been diligent in guarding against the surprise. Example: a party who relies on a witness's promise to appear voluntarily and who fails to subpoena the witness is not entitled to a new trial when the witness fails to appear. Rudin v. Lumen, 53 Cal. App. 212 1921. 1. Incompetent counsel 2056. A party is charged with the mistake of his counsel, so that a new trial generally will not be granted on the ground that counsel was negligent or incompetent. Calarosa v. Stowell, 32 SW2D 138 Mo. 2000. C. Timely application 2057. When surprise occurs, counsel must move for a mistrial or continuance at the earliest opportunity. Mitchell v. Int. Hood Meadows, 99 P3D 748 or 2004. 3. Newly discovered evidence 2058. A new trial also may be granted in order to consider evidence discovered after the trial. A. Requirements. 1. The new proof must pertain to facts in existence at the time of trial, not facts occurring later. Rivera Pomales v. Bridgestone Firestone, Inc., 224 FRD, 52 DPR, 2004. 2. The new proof must be highly significant, not merely cumulative. Willard v. Fairfield Southern Co., 472 F3D 817 11th Sir, 2006. 3. And the moving party must show that the evidence could not have been obtained by due diligence before trial. Toledo Scale Co. v. Computering Scale Co., 261 U.S., 399 1923. B. But note: a new trial should not be ordered when the discovery results from the failure of counsel earlier to appreciate the significance of available proof. Slemons v. Patterson, 14 Cal. 2D 612 1939. C. And note: generally, newly discovered evidence is a disfavored ground for new trial, and parties should not withhold or fail to develop proof in hopes of getting a second chance at a favorable verdict. Estate of Emerson, 170 Cal. 81 1915. 4. Improper evidence 2059. A new trial may be granted to correct an erroneous ruling on the admissibility of evidence, provided the error was prejudicial and was the subject of timely objection. 5. Verdict contrary to Law 2060. A new trial likewise may be granted if the evidence is not legally sufficient to support the verdict. An order granting a judgment NOV may also be appropriate if the procedural requirements for such a motion were met. See Supra 2040. 6. Weight of the evidence 2061. Finally, a new trial may be ordered if the judge finds the verdict to be contrary to the manifest weight of the evidence. Eatna Casualty and Surety Co. v. Yeats, 122 F2D 354th Sir, 1941. A. Standard for Decision 2062. The standard for decision has been expressed in different ways. An underlying policy concern is that motions for new trials on this ground not undermine the right to jury trial. If the judge can invalidate a jury decision on the ground she does not like it, the right to jury trial becomes insignificant. 1. Directed Verdict Standard 2063. Some courts phrase the standard in terms of whether there was substantial evidence to support the verdict, the directed verdict standard. Criticism: this seems overly narrow because the motion for new trial on this ground is intended as an additional safety valve in the jury system. On the other hand, when a party has failed to produce substantial evidence at the first trial, it is difficult to understand why the court should give the party a second chance and impose the cost of a second trial on the winner at the first trial. 2. 13th Juror Standard 2064. At the opposite extreme is the 13th Juror Standard, The judge may grant a new trial whenever she disagrees with the jury. Criticism. This seems too easy to satisfy. It would constrict the right to jury trial because a litigant must persuade the judge, as well as the jury, in order to prevail. 3. Majority Rule Miscarriage of Justice 2065. Between the 13th juror and directed verdict standards is the standard applied by most courts, the miscarriage of justice standard. Under this standard, the judge is to ask whether the jury has reached a seriously erroneous result. In answering this question, she may weigh the evidence, assess the credibility of witnesses, and draw inferences from the evidence. A. Possible exception. It has been held that as to non-technical matters, the court should not grant a new trial on the basis of credibility determinations, because those are peculiarly within the province of the jury. Lind v. Shenley Industries, Inc., 278 F2D 79 3D Sir. Cert. Denied. 364 U.S. 835 1960. B. Constitutionality 2066. Because the motion for a new trial on this ground existed at common law, there has been no serious challenge to its constitutionality, even though it may seem to erode the value of the right to jury trial. See Galloway v. United States, 319 U.S. 372 1943 discussing existence of motion for new trial at common law. C. Appellate Review. 1. Traditional Rule 2067. The traditional rule was that the weight of the evidence was to be assessed only by the trial judge, i.e., whether he granted or denied a new trial on this ground. His decision ordinarily was not reversible. The trial judge's ruling would be reversed only if a new trial was denied, and there was no substantial evidence to support the verdict, i.e., if there should have been a directed verdict. See Portman v. American Home Products Corp. 201 F2D 847 2D Sir. 1953. 2. Modern Rule 2068. Today, appellate courts may reverse the denial of a motion for new trial if it is determined that the refusal to grant the motion was an abuse of discretion. This means that if the evidence was seriously arguable, the trial judge should not substitute his view of the evidence for that of the jury. Lind v. Shenley Industries, Inc., Supra. 3. Review of grant of new trial 2069. An order granting a new trial is not immediately appealable because it is not a final judgment. On appeal from the final judgment following the second trial, however, the appellant may claim error in the grant of the new trial. If the appellate court agrees, it can reinstate the verdict from the first trial, although this rarely happens. 4. Excessive or inadequate damages 2070. The trial judge may find that the jury's award of damages is against the weight of the evidence. In such cases, a partial or conditional new trial may be ordered. See discussion of remittitor and additor, Infra 2089-2101. Such rulings are generally reviewable only for abuse of discretion. State substantive law on the standard for review of excessiveness or inadequacy of damage awards by the trial court, however, may supplant federal decisional law on that issue in state law cases in federal court. Gasparini v. Center for Humanities, Inc., Supra, 593. B. Grounds for motion non-jury trial 2071. If the trial was conducted without a jury, a motion for new trial is essentially a motion for rehearing. Such a motion may be granted on the following grounds. 1. Newly discovered evidence. 2. Erroneous findings of fact, and/or 3. Error in the conduct of the trial, e.g., erroneous rulings on admissibility of evidence. C. Procedural requirements for new trial motion. 1. Necessity for motion. A. Federal Rule 2072. A federal court may grant a new trial on its own motion. Fed. R. Civ. P. 59D. However, if the losing party does not make a post-verdict motion, and the district court does not grant a new trial on its own motion, the appellate court may not grant a new trial, even though the losing party made a pre-verdict Rule 50A motion for judgment as a matter of law. Unitherm Food Systems, Inc. v. Swift Eckrich, Inc. 546 U.S. 394-26. B. State Courts 2073. In some states, the court may order a new trial only on motion by a party. Cal. Civ. Proc. Code 659. 2. Timeliness of motion. A. Federal Rule 2074. In federal courts, a motion for new trial must be served within 10 days after entry of the judgment. Fed. R. Civ. P. 59b. B. State Courts 2075. State court time limits vary. In California, for example, the motion must be made within 15 days after notice of entry of the judgment. Cal. Civ. Proc. Code 659. 3. Affidavits 2076. A motion for new trial may be accompanied by affidavits if proof is necessary to establish the grounds. A. Time for filing 2077. In federal court, the movant's affidavits must be filed at the time of filing the motion. Fed. R. Civ. P. 59C state rules may allow later filing. Cal. Civ. Proc. Code 659A. B. No oral testimony 2078. Most courts refuse to accept oral testimony in support of a motion for new trial. Linhart v. Nelson, 18 Cal. 3D 641 1976. 4. Hearings 2079. A motion for new trial must be heard by the judge who conducted the trial, unless she is disabled. 5. Time for decision 2080. There is no time limit for the judge's ruling on a motion for new trial, at least in federal practice. A. State Laws 2081. Some state statutes impose a limit. Cal. Civ. Proc. Code 660. Failure to grant motion within 60 days after filing operates as a denial. D. Order. 1. In non-jury cases 2082. In ruling on a motion for new trial in a non-jury case, the court may order a full retrial or only a partial new trial, i.e., it may order the reopening of the judgment for the taking of additional proof, after which it may amend its findings of fact and conclusions of law or make new findings and conclusions and direct the entry of a new judgment. Fed. R. Civ. P. 59A2. 2. In jury cases 2083. In a jury case, the court must grant or deny the motion, but it may do so in parts or on conditions, e.g., new trial on damages only. A. Specification of grounds. 1. Federal Practice 2084. A federal court need not specify the grounds on which new trial is granted. 2. State Practice 2085. State rules on specifications of grounds vary. In California, if the ground is insufficiency of the proof, the judge must specify the respect in which the proof is deficient, and this specification is reviewable on appeal. Cal. Civ. Proc. Code 657. B. Excessive or inadequate damages 2086. If the judge finds that the jury's damage award is inappropriate, there are several alternatives. 1. Full new trial 2087. The judge may order a full new trial. This would be the only appropriate order if the award is so excessive that the judge concludes that the verdict is the result of passion. New York Central Railroad v. Johnson, 279 U.S. 310 1929. 2. Partial new trial 2088. As a time-saving move, the court may order that the new trial be limited to certain issues. However, such a limited new trial may be used only when it clearly appears that the issue to be retried is so distinct and separable from the others that a trial of it alone may be had without injustice. Gasoline Products Co. v. Champlin Refining Co. 283 U.S. 4094 1931. Example: when the low verdict for plaintiff indicates that it was a compromise verdict in which jurors who favored exonerating defendant altogether went along with a low award to plaintiff. A new trial limited to the issue of damages would be unfair to defendant. 3. Conditional new trial. A. Remittitor 2089. A remittitor is an order for a new trial, subject to recall if the plaintiff consents to reduction of the damage award. If the plaintiff so consents, a new trial is denied. 1 Constitutional 2090. Remittitor was recognized at common law and has been held consistent with the Seventh Amendment. Northern Pacific Railroad v. Herbert, 116 U.S. 642 886. 2 Proper Sum 2091. Courts vary in their approach to what is the proper sum for a remittitor. A fair amount 2092. Many courts hold that the verdict should be reduced to whatever amount the trial judge determines to be fair and reasonable, i.e., her estimate of what a properly functioning jury would have found, on the theory that this gives the plaintiff adequate incentive to avoid the costs and risks of a retrial. Powers v. Allstate Insurance Co., 102 NW2D 393 Wise. 1960. Cal. Civ. Proc. Code 660-25B. B. Lowest amount 2093. However, some courts reduce the verdict to the lowest amount that an impartial jury reasonably could have awarded, on the theory that this best protects the defendant from an improper award, and that plaintiff can always protect himself by accepting a new trial. Meissner v. Pappas, 35F. Sup. 676 ed. Wise. 1940. See highest amount 2094. Still other courts reduced the verdict to the highest amount deemed not excessive, on the theory that the jury's verdict should be upheld insofar as possible. Gorselitz v. Allen Matheson Chemical Corp., 429 F2D 1033 5th Sir. 1970. D. Note effect on plaintiff's election 2095. Note that remittitor gives the plaintiff the choice whether to proceed to a new trial or accept a reduced award. Using the lowest possible award standard 2093, supra signals to the plaintiff that this amount is the worst he can do at the second trial if he prevails on liability. Using the highest possible award standard 2094, supra signals to the plaintiff that he cannot expect to do better at the new trial and keep that result. Thus, adoption of the highest possible award standard will be more likely to induce plaintiffs to accept remittitor than the lowest possible award standard. 3 Waiver 2096. If the plaintiff agrees to a remittitor, most courts hold that he waives the right to appeal the propriety of the remittitor, except that if the defendant thereafter appeals, the plaintiff may cross-appeal from the reduction of damages ordered by the trial judge. Donovan v. Penn Shipping Co., 429 U.S. 648 1977 exception. It has been held that a plaintiff did not waive the right to appeal when a court reduced a punitive damage award pursuant to a constitutionally mandated reduction in such damages, and the plaintiff did not have a choice between consenting to the reduction or going to a new trial. Johansson v. Combustion Engineering, Inc., 170 F3D 1T320 11th Sir. Cert. Denied. 528 U.S. 9031 1999. 4 Appellate Court 2097. A federal appellate court may review a district judge's denial of a motion seeking remittitor, but only for trial court abuse of discretion in applying the governing standard. Gasparini v. Center for Humanities, Inc., Supra, 2070. State practice varies. For example, the California Rules of Court 864D expressly recognizes remittitor and additor by appellate courts of the state. A constitutional right to retrial 2098. In federal court, if the appellate court directs recalculation of damages due to excessiveness, the plaintiff has a right under the Seventh Amendment to reject the recalculated figures as too low and insist on a new trial. Hetzel v. Prince William County, 523 U.S. 208 1998. B. Additor 2099. An additor is an order granting a new trial, unless the defendant consents to an increase in the amount of the verdict. 1 Federal Practice 2100. Additor was not known at common law and has therefore been held forbidden in federal courts by the Seventh Amendment, i.e., as violating the plaintiff's right to jury trial on the issue of damages. Dimmick v. Skeet, Supra. 1848. The modern court has hinted, however, that it might be willing to rethink sympathetically the constitutionality of additor. Gasparini v. Center for Humanities, Inc., Supra. 2 State Practice 2101. Many state statutes and constitutions allow additor as well as remittitor. See, e.g., Cal. Civ. Proc. Code 662-5. 4. Entry of Reduced Judgment 2102. Some jurisdictions limit the amount of punitive damages available in tort cases and give courts power to reduce excessive awards. In the special and limited circumstance of a constitutionally mandated reduction of excessive punitive damages, one circuit takes the view that a trial court may bypass the usual remittitor procedure of granting a conditional new trial if the plaintiff accepts a reduction in the damage award. Instead, the court may enter judgment for the amount of punitive damages it finds to be constitutionally permitted. Johansson v. Combustion Engineering, Inc., Supra. 3. Motion to alter or amend judgment 2103. A motion to alter or amend judgment may be used to reopen judgments in both jury and non-jury cases. Fed. R. Civ. P. 59E. Cal. Civ. Proc. Code 663. A. Errors of law, only 2104. The purpose of the motion is to correct errors of law, and it cannot be used to secure a retrial on the facts. Examples. Vacation of a judgment would be proper when the judgment rests on erroneous conclusions of law, when necessary conclusions of law were omitted, or when the court erroneously asserted jurisdiction. B. Time limitations 2105. A motion to alter or amend judgment is subject to the same time limits as a motion for new trial. Fed. R. Civ. P. 59E. Cal. Civ. Proc. Code 663A. C. Supra. 2074-2075. 4. Motion for relief from judgment. A. For clerical mistakes 2106. If the judgment as entered by the clerk differs from that ordered by the court, the mistake can be corrected. Fed. R. Civ. P. 60A. Cal. Civ. Proc. Code 473D. 1. Procedure 2107. Corrections can be made on motion or sua sponte. 2. Timing 2108. There is no time limit on the power to correct. 3. Clerical mistake 2109. Clerical mistakes subject to correction by this motion may be those of either clerk or counsel who drafted the order or judgment, but not those of the judge. Judicial errors should be attacked by a motion to alter or amend above. B. Other grounds 2110. The court likewise may relieve a party from judgment on the following grounds. 1. Mistake, inadvertence, or surprise 2111. A judgment may be reopened for these reasons, but the circumstances must be extraordinary. The standard of care to which the moving party is held is much higher than would be applied in a motion for new trial. Fed. R. Civ. P. 60B1. Burchad v. McDonough. 469 F2D 13333 7th Sir. 1972. Cal. Civ. Proc. Code 473B. Martin v. Taylor. 267 Cal. App. 2D 112 1968. 2. Excusable neglect 2112. The court may reopen a default judgment for excusable neglect. However, neglect of counsel is not a sufficient ground for relief. Universal Film Exchanges, Inc. v. Lust. 479 F2D 573 4th Sir. 1973. 3. Newly discovered evidence 2113. The court may reopen a judgment to receive additional proof, but it must be shown that the moving party, by reasonable diligence, could not have discovered the new evidence in time to move for a new trial under Federal Rule 59. And the proof must be more than cumulative, i.e., it is not enough that the moving party has now devised a new factual theory to explain the proof. See Stillwell v. Travelers Insurance Co., 327 F2D 931 5th Sir. 1964. The standard is essentially the same as that used on a motion for a new trial on this ground. See Supra, 2058. 4. Fraud or misconduct 2114. A judgment may be reopened for fraud or other misconduct, e.g., a judgment obtained by the use of perjured testimony. Fed. R. Civ. P. 60b3. Peacock Records, Inc. v. Checker Records, Inc. 365 F2D 145 7th Sir. 1966. A. Burden on party guilty of fraud 2115. The responding party then has the burden of showing that the fraud did not affect the outcome. Hazel Atlas Glass Co. v. Hartford Empire Co. 322 U.S. 238 1944. Example. When defendant in a products liability action failed to produce a document called for by an order compelling production of documents, its failure to do so constituted misconduct. Since production of the document might materially have affected plaintiff's presentation of the case, judgment for defendant was vacated. Rosier v. Ford Motor Co., 573 F2D 1D 5th Sir. 1978. 5. Void judgment 2116. A judgment may be reopened if it is void as when no notice was given before the entry of a default. Base v. Hoagland, 172 F2D 205 5th Sir. 1949. 6. Change of circumstances equitable relief 2117. When the judgment provides for continuing equitable relief, as when an injunction is granted, the court may reopen the proceedings to consider whether supervening events make the old decree inequitable. Fed. R. Civ. P. 60b5. De Philippis v. United States, 567 F2D 341 7th Sir. 1977. A. Note. This ground is generally not applicable in the case of money judgments. Ryan v. United States Lines, 303 F2D 432 D Sir. 1962. B. And note. The parties may not contract to bar the court from considering the continuing equity of a decree. It is an abuse of discretion to refuse to modify a decree that no longer fairly serves its original purpose. System Federation No. 91. Railway Employees Department v. Wright, 364 U.S. 642 1961. 7. Relief otherwise justified 2118. Under the federal rules, the court may also reopen a judgment for any other reason that justifies relief. Fed. R. Civ. P. 60b6. However, this rule has been sparingly applied, and the courts have frequently emphasized that it is not an alternative to appeal. Ackerman v. United States, 340 U.S. 193 1950. Example. Subsequent state court interpretation of state law different from a federal court's interpretation of the same state law in a federal case that has become final is not by itself an extraordinary circumstance justifying relief under Federal Rule 60b. See, e.g., Kansas Public Employees Retirement System v. Reamer and Koger Associates, 194 F3D 922 8th Sir. 1999, cert. Denied, 120 S. CT. 1-268 2000. An exception. A federal court interpreted a state law differently from the way the state Supreme Court subsequently interpreted the same state law in a case involving another claimant injured in the same accident as the plaintiff in the federal case. The need to correct the federal court's erroneous interpretation of the state law in this exceptional circumstance was held sufficient to justify overriding the usual rule that mere error does not warrant disturbing a final judgment. Pierce v. Cook & Co., 518 F2D 720 10th Sir, 1975, Cert. Denied, 423 U.S. 179 1976. C. Time limits. 1. Federal Practice 2019. A motion for relief from judgment must be made within reasonable time. This cannot be more than 1 year from the entry of judgment if the ground asserted is mistake, inadvertence, surprise, excusable neglect, newly discovered evidence, or fraud. Fed. R. Civ. P. 60C1. A. But note, there is no outside time limit where the ground is that the judgment is void or satisfied, or that there are other reasons justifying relief, see above. 2. State Practice 2120. Time limits in state courts vary. In California, the period is 6 months from the entry of judgment. Cal. Civ. Proc. Code 473b. D. Distinguish independent suit to set aside judgment 2121. A motion for relief from a judgment must be distinguished from an independent suit in equity based on similar grounds. The motion is addressed to the court that entered the judgment, whereas the independent suit may be filed in a different court. In addition, the grounds for an independent suit in equity tend to be narrower and more strictly scrutinized than those for a motion for relief from judgment. Lappin v. Schulten, Inc., 333 F2D 169 9th Sir. 1964. 1. Grounds for independent action 2122. The two basic grounds for an independent equity suit for relief from judgment are I. Jurisdictional defects, and Roman II. Fraud, as when a plaintiff was induced not to appear or contest the case by a false promise of settlement. See United States v. Throckmorton, 98 U.S. 61 1878. Kulchar v. Kulchar, 1 Cal. 3D 467 1969. A. Former limitation 2123. At one time, relief through an independent suit could be obtained only if the fraud was extrinsic, as distinguished from fraud such as perjury. However, this distinction has now been repudiated by most courts. Publicker v. Shawcross, 106 F2D 9 out of 49 3D Sir. 1939. B. Modern limitation 2124. Relief from a federal court judgment by an independent action is authorized only to prevent a grave miscarriage of justice. United States v. Beggarly, 524 U.S. 38 1998. Alleged failure of adversary to search its records thoroughly and to make a full disclosure did not provide sufficient basis for vacating the judgment. 2. State-federal relations 2125. A federal court may refuse to entertain an independent action in equity to set aside a state court judgment. Macobo Investment Corp. v. Von der Heide, 243F. Sup. 885D. MD. 1965. 3. Relation to motion for relief 2126. Seeking relief by motion in the main action is not a prerequisite to the independent action. However, if such relief is still available in the main action, the equity court may choose not to act because there is an adequate direct remedy. A. Note: if the ground for relief asserted in the equity suit was previously presented to the court that entered judgment and was held insufficient to reopen the judgment, that decision is res judicata. 4. Jurisdictional basis 2127. A federal court has subject matter jurisdiction to entertain an independent action to set aside a federal court judgment ancillary to its jurisdiction over the original action. See Supra. 440-448. United States v. Beggarly, Supra. 5. Coram nobis. A. State Practice 2128. In some states, The common law writ of coram nobis is still available. The purpose of the writ is to declare as false a fact previously determined to be true, as when a witness recants perjury, or evidence previously concealed by a party comes to light. 1. Cautiously applied 2129. Writs of coram nobis are granted only if no other remedy is available, and it is absolutely clear that the evidence involved was crucial to the outcome of the case. Rollins v. City and County of San Francisco, 37 Cal. App. 3D 145 1974. B. Federal Practice 2130. In federal practice, the writ of coram nobis has been abolished.